Thank you both. Next case on the docket is Good Time Billiards versus U.S. Bank.
Good morning, Your Honors, and may it please the Court. My name is Karen Wansettler on behalf of co-counsel Kevin Cannon, who is unable to be here today. I represent the appellant, Good Time Billiards, Inc. Good Time Billiards, Inc. is an unusual defendant in that is not the borrower involved in a residential foreclosure matter. It is a judgment creditor that was brought into the matter via an amended complaint. The standard of review and the burden of proof in regard to this foreclosure matter would not change, and that this trial court's review is still, in fact, de novo, and the party seeking to foreclose bears the burden of proof that it had standing at the time of the action to bring this complaint. This is a matter where the appellant does appeal the final judgment that was entered by the trial court in favor of the lender, U.S. National Association, and also...
Did the copy of the note have an endorsement in blank?
There was no copy actually introduced into evidence at any time during the trial. It had one endorsement, and then there was later...
Correct.
It was in blank, and then later there was a second copy of the note subsequently filed with two endorsements. By way of procedural history, this original complaint was filed in January of 2010.
Isn't the copy of the note attached in blank to the pleading sufficient to show standing?
No, Your Honor, because when you couple it with the witness's testimony as to why there was a second endorsement, the bank's own witness, under questioning by Judge Playas, stated that it was the second endorsement that gave plaintiff the standing to bring suit. There was never a change in the plaintiff in this matter. In January of 2010, when the complaint was filed, there was one endorsement. Homecomings was the original lender. After the borrower, Maurice Yelps, filed a motion to dismiss alleging standing, was there a notice of filing in May of 2011 whereby a copy of the note with two endorsements was then attached. So the original complaint had one, an amended complaint had two.
That's not inconsistent to have an endorsement in blank and then subsequently endorse it over to a particular entity, right? I mean, the issue that you raised was whether they had standing at the outset, and isn't that established by an endorsement in blank?
It can be, Your Honor. The testimony of the bank's sole witness testified that it was the second endorsement that established U.S. Bank standing. There was an intervening commercial entity, RFC, Residential Funding Corporation, that at no time was a party to this complaint, and it was at trial that the allegation, based upon the testimony of the bank's witness, that it was this second endorsement, undated, unendorsed, that would have established the bank standing.
I understand your argument. There's two issues. One, whether the plaintiff was the holder at the time of trial.
Yes, sir.
And one, whether the plaintiff was the holder at the time that the lawsuit was filed.
Yes,
right?
sir.
Okay. The attachment of a endorsement in blank establishes that they were the holder at the time that the complaint was filed, and the endorsements over to the plaintiff established that they were the holder at the time of trial, right?
At the time of trial, but not at the time the suit was filed. And as this court...
That's why I addressed the issue of it in blank. It was attached and endorsed in blank at the time the lawsuit was filed, right?
Yes, sir, it was. And then contradicted by the testimony.
That's not contradictory, is it?
It is, in fact, that the bank's own witness testified that, in her opinion, she used the terms, it was not an issue to, after the fact, have an endorsement to the plaintiff over 13 months after the suit was filed, as long as you could produce the original note, which was not done in this case, despite 7 repeated requests on the record by Mr. Cannon, who was...
The original note was filed by the bank.
Purportedly. The witness stated she had never seen a copy of the note, and that as she...
The record bear out that the original note was filed.
Only by, if you were to take judicial notice of a notice of filing from May of 2011, whereby the attorney captioned it as the original copy, what had happened thereafter. And this predated my client's involvement before being brought in by the amendment, alleging that we had an inferior interest in the property.
There was some issue that came up in trial as I recall, about the presence of the note at the trial itself. What was that all about?
What that was all about is Mr. Cannon repeatedly requested to see a copy of the original note, asked the witness if she had ever seen a copy of the original note. She said no. What she had been provided was a copy.
Was the file at the trial?
No, sir. No, sir, it wasn't.
Whose responsibility was it to get the file?
Absolutely, this is upon the lender. They carry the burden of proof. They would carry the burden of proof to bring forth the original note if that is the theory that they're proceeding upon. There's never been an allegation of lost note.
Does the original note have to be introduced into evidence in order to obtain a judgment in a foreclosure action?
In this case, yes, because the reliance was in part to bolster.
As a general proposition?
I would say yes. I know Deutsche Bank versus Huber has ruled that when the filing goes into the clerk of court, say for a motion for summary judgment packet, that it can still be proven up that it was in possession of the court prior to entry of a final judgment. In this case, however, the only witness to provide testimony said she had never seen the original note, was relying upon communication from the bank's attorney that that was the original note from 2011 when Ocean wasn't even the servicer until 2013 per her testimony. So while it can be done, Your Honor, in this case, the theory of the bank was to proceed upon explanation of the second endorsement after the fact, coupled with the original promissory note, which despite 7 requests, Mr. Cannon, as defense counsel, offered to go get the file and was denied by the judge in the middle of trial because he needed it for the purposes of cross-examination. The witness, when asked about why 1 endorsement and then 2 endorsements, says, I don't know when they were dated. I don't know why, because it's not an issue, because as long as we produced the original note, we were the holder of the note. But the original note was not provided, and that is undisputed on the record before you. So we have these 2 copies of the notes that were marked by Mr. Cannon as defense exhibits for identifications, one with 1 endorsement, one with 2 endorsements, both undated, both blank. No original note was ever presented during the trial.
Copies introduced into evidence?
No, the magic words of, Your Honor, I would like to move into evidence were never uttered by either plaintiff's counsel. Plaintiff's counsel did not ask one question of its own witness. The litany of the trial transcript shows Judge Plius asked every single question. I do apologize, I pronounced that incorrectly. I know he is a member of this court, and I mean no disrespect, but his questioning was the sole questioning in the plaintiff's case in chief. Now, there were introduced, after the fact, copies of the payment history. Mr. Cannon, as defense counsel, marked for exhibit the first copy at record 21 with 1 endorsement, and at record 34, the second endorsement on the same page as the 1 endorsement. So 1 endorsement and then 2 on the exact same paperwork. The copies of the notes so that he could at least effectively question the witness. But he did not move them into evidence, nor did plaintiff's attorney move the documents into evidence. Judge Plius, in the testimony, stated he was looking at a computer screen. We're not even sure if he was looking at the 1 endorsement or the 2 endorsements based upon the record as presented. Now, in the matter of this court, it's your recent decision from Friday of last week in the Guzman, Gonzalez versus Bank of America Home Loans, this court took exception with blank undated endorsements. In that case, there was no endorsement on the note, and then 1 endorsement produced later.
You just hit the distinguishing fact. In that case, there was no endorsement on the note that was attached to the complaint, right?
Mm-hmm. Yes. Yes, Your Honor.
Different from this case.
Correct, but this court still held the bank to its proving standing at the time of the filing of the complaint, and this court said that you needed more.
That was what we said was the omission in that case, was that the copy of the blank endorsement wasn't attached to the complaint, right?
Yes, but similar to the Gonzalez matter, Your Honor, the bank's witness and sole witness failed to give the necessary testimony at trial to support not just, and in the Gonzalez case, Your Honor, the original note was moved into evidence, unlike in this case, which is an important distinction, and then the testimony was still attempted to explain it. This court held that there still was not sufficient witness testimony as to when the plaintiff came into possession of the note. The exact language of the bank's witness was, I don't know the date of either endorsement. I don't know. No other personal knowledge, no other business records, and as far as the allegation that the original note was submitted previously to the court via the clerk of the court as part of a notice of filing, The witness simply stated, well, this was the documentation provided to me by the attorney, which clearly that's out of any business records custodian role she would have in dealing with what are the records as kept by counsel.
She testified that she had compared it to what was in their system on the computer.
She said after the fact. She took what was given to her by the attorney, and then she looked in her system. And again, the notice of filing was from 2011. Oshwin, the servicer whom she had worked for 2.5 years, was not involved in this loan per her testimony until 2013. She could not explain the second endorsement, and again, her only testimony was, it's not an issue, because in her opinion, there was no requirement, because it's in the blank, that they could simply go back and in fact, backdate, give retroactive effect to the U.S. National Association as trustee, as plaintiff, as the only plaintiff in this matter, without circumventing the requirement under Florida law that you must prove possession of the note at the time the lawsuit was filed. This is very similar to the fourth DCA in Guzman, where the original note was attached. There was one endorsement at the time, and then a second amended complaint with a second endorsement. The Fourth District Court of Appeals said, no, you're trying to circumvent.
Distinction, again, in those cases, they needed that second endorsement to have standing. And so what the courts were saying was there was no, you filed something that showed you had no standing attached to the complaint. After the fact, you came up with a later document that gave you standing, and you put on no evidence to show that you possessed the, so there was a question here. The document attached to the complaint would give them standing.
Correct, and then the testimony of the defense, or the bank's witness, actually bolstered the defense's motion for involuntary dismissal. When the bank's witness stated, I don't know why the second endorsement was needed, I don't know why when the second endorsement was executed, she did, without any equivocation, testify that there was an intervening commercial entity. Homecomings to Residential Funding Corporation to U.S. National Bank. And all that can be told by the record before this court is that that endorsement to RFC, and then from RFC to plaintiff, came at least 13 months after the lawsuit itself was filed. That is what is presented and preserved by the record in front of you, bolstered by the bank's witness's own testimony. And to the extent, I do apologize, I did mean to request 5 minutes for rebuttal. If I may keep track of my own time, I see that I've just gone under 8 minutes. If I may request closer to the 5-minute mark, that I preserve any remaining time. To the extent that the original note was not presented despite repeated requests, objections, offers to go and obtain it from the clerk of the court, it's the Osceola County Courthouse. The courthouse is on the 6th floor, the clerk's on the 2nd floor. There was a request to actually go get the original by defense counsel. I understand that while it may not be fatal to introduce the note at trial if it had been previously presented with the court, I would argue to this court that in this case it is required based upon the theory that the bank was proceeding under, which was to explain away the second endorsement via its own witness testimony to prove that it was the holder of the note at the time the lawsuit was filed. Because the original note was not introduced into evidence, and in fact because a copy of either the one endorsement or the two endorsement note were entered into evidence, they weren't even attempted to be entered. And I think it's safe to say from a reading of the testimony, it would have been admitted as a bank evidence, but it was not. Because you have no copy of the note in the record on review, it would be impossible for the bank to establish that it had standing based upon the record as presented. As to whether or not the original note were necessary, if it were in the court file, if you could call it testimony, bank's counsel stated, well, there had been a notice of filing. Nothing more, nothing less. And in terms of whether or not that can be evidence, I would proffer to this court that that's non-testimonial, nor was it corroborated. The witness specifically said, I have never seen the original note. To that was a failing of evidence by the bank's attorney, who had the burden of bringing competent, substantial evidence through competent, knowledgeable witnesses as to the chain of custody of the original note. That was not done in this case. And unless there are any further questions, I would like to reserve my remaining just under 6 minutes for rebuttal.
Okay.
Thank you, gentlemen.
May it please the court, Your Honor, it's Michael Smith on behalf of U.S. Bank, the plaintiff. And Your Honor, I want to make it clear that we've already discussed the sole salient point, which is that U.S. Bank had standing to foreclose at the time the lawsuit was filed. There was an endorsement. The endorsement was in blank. That copy of the note with the blank endorsement was attached to the complaint.
Was there a copy of the note or the original note introduced into evidence at trial?
The note, as we said, the magic words, I'd like to introduce into evidence, no, those words were not uttered. However, I think it is abundantly clear based upon the
Was it
transcript.
received into evidence? Was it marked into evidence? Is it evidence?
The defendant put it in as an exhibit. He did not move it into evidence.
He identified it as an
He identified it as an exhibit. The court took judicial notice of the fact that the original note had been received into the court file. There doesn't appear to be any question in anyone's mind. The court...
He was looking at a computer image, he said, of that in the court file?
That's correct, Your Honor.
Record.
He stated that the original note was filed, that he looked at it, and he made a specific finding on the record to let it reflect that the note that I am looking at is the same as the copy that everyone is looking at. There's no question that the copy of the note that everyone had at trial, the witness, the judge, opposing counsel, it looked exactly like the original note.
To the extent that the original note must be introduced at some point in time during the proceeding, how can you tell whether it was original note or not if the file wasn't there?
Well, Your Honor, the court said that the original note had been filed. I agree that would have been a better practice to have the note actually introduced, but in this particular proceeding especially, this is a judgment lien creditor. This is not the borrower. The purpose of surrendering the original note was so it can't be negotiated any longer. That's not an issue with the judgment creditor. The borrower had been defaulted years earlier, was not contesting the action. The only reason that the note needed to be introduced was so it couldn't be enforced against the borrower again. For the purposes of this particular action, where the posture of the case, it was harmless error. It was irrelevant. The note had been filed. The court acknowledged that the original note had been filed. The court said the copy that everyone's looking at looks exactly like the copy that was filed. There was no question as to what the terms of the note were, and that is what the argument actually is. The appellant is arguing that the bank did not have standing because of what was actually written on the note. The lack of the original note, I don't think, was fatal to the proceedings in this particular case. The witness testified that the endorsement was on the note, and that subsequently, after the complaint was filed, these additional endorsements were added on. The fact that there were subsequent endorsements is not fatal at all. And the court and Your Honors brought this to light. The difference in all the cases that were cited, appellant cited cases in the brief, the Green case, the Joseph case, the Bristol case, the Gonzalez case. Every single one of these cases, there was an issue because the note that was attached to the complaint did not show that the plaintiff had standing at the time the complaint was filed. In Joseph, the note was not actually attached. It was later provided, and there was no evidence as to when the plaintiff had standing. In Green, the note attached to the complaint was not endorsed. So again, there was a problem with standing. In Bristol, the same thing. The note with the endorsement was filed after the complaint. The key difference is that U.S. Bank showed that it did have standing. There is no case law, there's no statute that prevents additional endorsements from being added after the case is filed, especially when those endorsements still show that U.S. Bank had standing at the time of trial. And opposing counsel said that there was backdating. There was nothing of the kind. There was no attempt to say that this specific endorsement to U.S. Bank is what gave them standing. There was never that testimony, and that was stated in her initial argument. The testimony was not that this specific endorsement to U.S. Bank is what gave the plaintiff standing to foreclose. The witness said that the endorsement attached to the complaint was what gave the standing to foreclose, and then the subsequent endorsements were added, and that the note just clarified, the endorsements clarified the standing of the plaintiff to proceed. She doesn't have to know when those endorsements were placed on there. She doesn't have to know why those endorsements were placed on there. It is plainly irrelevant. The fact is that the law says that the plaintiff has to have standing at the time the lawsuit was filed, at the time the complaint, or I'm sorry, at the time of trial. It is clear that despite the procedural irregularities of not producing the original note, that the original note was in the court file. It is clear that the plaintiff had standing. Also, opposing counsel mentioned several times, she said the word possession. That was never argued. She said that the plaintiff did not have possession of the note. That was never briefed, that was never argued. That is not the basis of their appeal. The appeal is solely based upon whether or not the plaintiff had the right to enforce the note based upon the endorsements. And it is plainly clear from the record that the plaintiff did have the right to enforce the note, and the plaintiff did have standing.
Any questions? Okay, thank you.
Thank you.
Thank you, and briefly, Your Honor. In regards to the fact that my client is a junior lien holder is absolutely irrelevant, be it a borrower or a junior lien holder. The plaintiff coming forward to foreclose has the burden of proof and must, in fact, establish standing.
The point is, in terms of the surrender of the original note, it may be harmless.
I understand that taking the note out of commerce is far more important to a borrower who would otherwise be obligated to it, but it is not omitted if only a junior lien holder or a defendant who's claimed to have an inferior lien holder is disputing the matter. They still must clear all the hurdles, if you will, for a proper foreclosure. In regards to, the only exception I truly take with counsel's statement was that the original note was in the file. There is no testimony before this court by anyone with competent...
Well, Judge Ployce made that statement, made that finding.
Based upon no witness testimony, based upon no proffer, basically it was upon his opinion.
The court can take judicial notice of its own records, can it?
It can, but there was no, the challenge as to, this was raised in the trial transcript as to whether or not that was in fact the original, was raised at trial. And that was, the objection was noted, overruled, and the matter went on. But it was preserved for this court as to whether or not a mere statement by a judge that, well, it says it's an original.
Is the original note in the file?
I can honestly tell this court, I do not know. What has been provided as part of the record are copies. And that is all that the testimony supported, is that, well, at least it's a copy that matches up to the copy in my computer screen.
We have an electronic record.
And that has been one of the issues, and I can say from a practical standpoint, when I file commercial foreclosures on behalf of banks that are clients of mine, I file the original with the complaint. And I do so via a hand delivery process, and the clerks will allow that so that I'm not electronically filing something I'm calling an original. And that has been an issue facing the courts nowadays.
It still ends up on our desk as an electronic file. So.
I agree, and it's understood. I would keep focusing on the fact that the bank's witness said, I've never seen the original. I've seen what's been provided by the attorney, it matches what's in my system. Because the testimony of the witness was not based upon personal knowledge, and because the bank introduced no business records, the standing cases counsel cites that are favorable to a bank's position, the original note was produced at trial. In this case, not even a copy of the note was produced at trial. At most, 2 copies of the note were marked for identification purposes and questioning, but were not submitted into evidence.
Was that precise argument made that the copy was not introduced into evidence?
Yes, Your Honor. In the reply brief by Mr. Cannon.
I mean below, was there an objection made on the basis that a copy has not been introduced into evidence?
In the motion, the first motion for involuntary dismissal, that was one of the grounds. In the second motion for involuntary dismissal, presumably upon the same grounds, Mr. Cannon was cut short as to stating his grounds, but twice he moved for involuntary dismissal. One of the grounds was failure to produce the note, original or copy, into evidence. Again, the second motion for involuntary dismissal that came later was simply, I move again for involuntary dismissal, denied. But to the extent that, yes, it was preserved in the record, Your Honor, again, in this case, no original, no copy of the note was entered here, and that is a failing by plaintiff in carrying their burden of proof. And the standing, which was originally raised in its affirmative defenses, has been an issue since day one in this matter. It predated my client's involvement when the borrower raised it under a motion to dismiss prior to the amended complaint being filed and the second endorsement coming to light. This case has been at all times about whether or not standing was established at the time the suit was filed in January of 2010. And because no note, original or copy, was presented, and because the witness's own testimony was wholly insufficient to support any conclusion that the plaintiff held via that second endorsement standing at the time the complaint was filed, I would respectfully request that this court reverse the final judgment and enter an order granting the motion for involuntary dismissal. Thank you.
Thank you for a well-argued case.